Well, hello there, everyday Americans. This is Paul Engel with the Constitution Study. I am glad you could join me here for the very first episode of the Constitution Study live. As you can see, still working on some of the lighting and some of the effects, but we are here to read, to study the Constitution, and we're here today to try something new. I'll give you an idea of what the layout's going to be. I have a couple of stories we're going to discuss, give you some updates as to what's going on, and then we'll have time at the end for questions and answers. And that's going to be an important part of the Constitution Study Live. So if you want to ask a question, please just ask it in the comment section. We'll get to those towards the end of the program. We will take it from there. I do want to thank a couple people. I want to thank Dustin and Jesse with the Constitutional Grassroots Movement, who've really helped move things along and spread the word about this. I also want to thank Melina at Live for Liberty and the Daughters of Liberty. She's really helped me put together some of the stuff that we are doing here. And without further ado, let's get into the fun stuff, the why you're here. And that is, let's talk a little bit. We're going to talk today about red flag laws. They've been in the news lately through the end of 2018. And if you're not familiar with them, a red flag law, they're promoted as ways to help prevent mass shootings. You know, the idea behind them is there have been several mass murders, which is probably a better term for them, where there were signs beforehand. There were things that said there's something wrong here. They called them red flags, and there was kind of a lot of discussion about why police didn't do anything about these red flags. Of course, they tend to ignore the fact that the red flags some of them only showed up in hindsight. Some of them really there was nothing legally the police could do about it. So several states, I think 12 at this point, I'd have to double check, are instituting these laws. Now, okay, they've been ignored, and we'll just put aside the fact that all the evidence that legal access to firearms or restricting legal access to firearms really does little to stop someone who's really willing to kill. I want to focus on the constitutional issues here because there are many of them. Now, a lot of people focus on the Second Amendment violations, and we'll mention that, but there's so much more. There's so many ways that these laws are they're just wrong. So if I may paraphrase Elizabeth Barrett Browning, Constitution, how do we violate thee? Let me count the ways. Well, as I said, the most obvious is it's a violation of the Second Amendment. It's the most obvious. You know, it never ceases to amaze me how the phrase, the right of the people to keep and bear arms shall not be infringed, simply cannot be understood by such a large swath of the American people. Not just the political class, not just the pundit class, but even the American people. Now, I understand there are millions of people, and maybe even some of you, who don't like the Second Amendment, but pretending it's not there or that it says something it doesn't, well, that's just not right. And it doesn't work. You see, what if we decided that there was another right, maybe one that you cherished that we thought maybe should be restricted because, I don't know, someone thought you might use it badly? What if the government decided you needed a permit to publish on the internet because, well, someone might use hate speech? We hear a lot about hate speech nowadays, don't we? What if the government decided your right to assemble could be taken away because a family member said you might become violent? You see, if you're going to strip Americans of some of their rights, like the right to keep and bear arms, would you at least have the common courtesy and the honor to do it legally through a constitutional amendment instead of, well, kind of underhandedly and with illegal laws and ridiculous claims about how they're going to protect us? So that out of the way, let's go on and let's look at the Fourth Amendment. You see, the Fourth Amendment reads the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the people, persons, or things to be seized. You see, we have a right. You have a right. I have a right. We all have a right to be secure in our homes and on our property. Our property is to be secured. against unreasonable searches and unreasonable seizures. But how secure are you? Really, if someone can make an unsubstantiated claim and your house is entered and your property seized, but Paul, you say, they have a warrant. But what is that warrant based on? Has someone sworn or affirmed that you're making plans to do something illegal? Do they have evidence you're preparing to do harm? Maybe yes, maybe no. Do they have evidence? See, if they don't, then at best, this is what someone thinks. You may be dangerous. Are they prepared to swear in a court of law that you're dangerous? Because if they're not, then the warrant's not valid. Well, if they tell law enforcement and law enforcement swears in a court, I think they call that hearsay evidence. And again, the warrant is not legal. And of course, no human being has ever lied to get back at someone they're mad at, right? I mean, no one in a nasty divorce or custody battle would say a spouse is a danger out of spite, would they? Has anybody ever called the police because they don't like what their neighbor is doing, even though it's perfectly legal? And there's never been a situation where someone has falsely made 911 calls saying someone is threatening people because they didn't like they possessed a firearm. See, now, if you believe any of that, then we'll have a nice bridge to sell you. You see, what we're talking about is basically legalized swatting, the legal ability to call the police on someone to have their property seized. And we've already seen, I'm sorry, I don't have the exact instance, but a gentleman was killed because the police got a warrant to seize his guns. They showed up and pounded on his door at 5 o'clock in the morning. They apparently, as I understand it, didn't announce themselves. They just pounded on his door. So guess what? He showed up with a gun, wondering who it was. And when the police saw the gun, they shot him. Is that really the world you want to live in, where your neighbor can call the police on you with no proof? And then what happens when the government no longer needs reasonable, probable cause to search and seize? You see, we don't really think about this, but if the right can be denied for a gun-related accusation, what about fertilizer? You know, you could be using it to make a bomb. And what if your neighbor calls because you have antihistamines? Because you could be making drugs. Or maybe you have dairy products. You know, the purchase of raw milk is extremely dangerous, and the government doesn't like you doing that. See, we really want to stop and think. It's not, as much as this is a Second Amendment problem, this is so much more. It's about basic property rights, which brings you to the Fifth Amendment. See, the Fifth Amendment says no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. You see, you not only have a right to your property, the government cannot take it without due process. And no, it's not just process, it's due process of law. That literally means that which law or justice requires to be paid or done. Is it justice taking someone's property without proof of their bad actions? Or is it right to punish someone for something they haven't done and may not even do? You see, if all it takes is an accusation, then why stop at taking property? How long before an accusation without proof is enough to put you in jail because you might be a danger to society? Will we have drunk driving red flag laws? Will your car be seized because a friend or relative is afraid you might get drunk and drive? What if they take your smartphone away because someone said you might text while driving? Or maybe not use your hands-free device? We all know how dangerous that can be. When people realize that more people are killed with fists and feet than they are with firearms, will they come and take those as well? Just because someone accused you? Now, this actually takes me on to the 14th Amendment, which says, the part I'm quoting is, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of laws. See, if you're a citizen of the United States, states are not allowed to abridge your rights or your privileges or your immunities. Yet states are passing laws to do so. And guess what? We're going to find out in a few minutes. Congress is going to help. At least they're trying. They're going to directly abridge your rights on the assumption that an innocent person is guilty until proven otherwise. See, we're supposed to have an expectation of innocent until proven guilty. All these red flag laws flip that on its head. Now you're considered guilty once you're accused, and you have to prove your innocence. All because someone believes that you might be dangerous. Do you notice all those times I'm referring to those qualifications? It's not proof. It's belief. I know a lot of people that believe a lot of weird things. And it's not that you have done something, or even that it's imminent that you do something, but that you might do something. You see, apparently those who represent us in state legislatures believe that your friends, family, neighbors, well, they're like the pre-crime unit in Minority Report. They're able to predict crime, and they're assumed to be infallible. Now, if this was Napoleonic France, the presumption of guilt was expected. But this is America. We're supposed to be better than that. The government is supposed to prove its case before punishing someone, and it's supposed to prove we're guilty before taking our property and our liberty as well. We're to have the same protections under the law as everyone else. Why are gun owners given special second-class citizen status? Why? See, if the government can take something, can enter your home and take it without proving your guilt, if they can't take anything else in your home, why can they take your gun? If they can't take your car without proof, why can they take your best tool for self-defense? If you can be declared a second-class citizen, or if your rights can be declared null and void just because you exercise one of them, well, what's to stop the government from declaring all of your rights null and void? What if your rights could be taken away for petitioning the government for a redress of your grievances? What if the laws no longer protected you if you asked for a lawyer or wanted to confront the witnesses against you? What if they passed laws that prevented you from exercising your right to vote because someone didn't like the way you used it? And before you think this is impossible in America, remember, Jim Crow laws were passed not only because blacks were voting, but because they were voting against the established Democratic Party. See, red flag laws are basically an emotional and irrational reaction to people who fear people with guns. Now, they'll say they fear guns. What they really fear are people with guns, because if there's a problem, the first people they call are people with guns. These laws are unconstitutional, and by that fact, they are illegal. Even worse, they are a giant step away from liberty and toward tyranny and despotism. See, if friends, family, and even law enforcement officer can take away any of your rights by simple accusation, how long before we become a nation of informants? Using that power we have to destroy the lives of others. How long before we walk around wondering which of our neighbors is going to inform on us? It sounds like East Germany. And again, not because of something we've done, but because of something they fear we may do. Or even worse, just because they have a vendetta. See, now is the time to begin exercising what we're learning in the Constitution study. And I got some more details on that because I wrote the article on the red flag laws and then stumbled across something even worse. It's called H.R. 5717. That is Hotel Romeo 5717, called the Jake Laird Act of 2018. And if you haven't heard, the title of the bill, quoting from the bill, is, quote, to authorize the Attorney General to make grants to states that have in place laws that authorize the seizure of firearms from dangerous individuals and for other purposes. The language in this bill is so disgusting, so repugnant to the Constitution, that when I first read it, I felt I needed a shower just for reading it. And I want to go through some of the details of just how awful this law is. And then I want you to start making some phone calls. But let's start from the beginning. Quoting from the bill, H.R. 5717, the Attorney General is authorized to make grants to states that have in place a law which authorizes the seizure of a firearm from a dangerous individual in accordance with Section 4. Now, nowhere, trust me, I've read a lot, nowhere does the Constitution delegate to Congress the authority to spend money in an effort to influence state legislatures. Right? Article 1, Section 8, Clause 1 allows, quote, Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and to provide for the common defense and general welfare of the United States. Right? And notice that Congress can collect and pay for the common defense and general welfare of the United States. One thing that's often lost, the United States in the Constitution refers to the federal government as opposed to the United States of America or the several states, which refers to the Union of States. They are not allowed to collect taxes from you, from me, from anybody to spend on the states, nor are they authorized to tax us, to take our tax money to peddle influence to the legislature of the states. But look at what they're doing. Quote, a state that receives a grant under this section may use such grant to implement the law described in subsection A and to train law enforcement officers and prosecutors on the implementation of such a law. In order to be eligible for the grant under this section, a state law shall provide for a process that is substantially similar to the following. In other words, they're going to pay for states that either want to implement this law, they can use the money for that, or once they've implemented, trained their LEOs and their prosecutors on the implementation of law, but it has to meet certain criteria that Congress provides. You see, the proper term for what this is not a grant. This is a bribe. See, if you look at the dictionary, bribe is a price, reward, gift, or favor bestowed or promised with a view to pervert the judgment or corrupt the conduct of a judge, witness, or other person. To give or to promise a reward or consideration with a view to pervert the judgment or corrupt the conduct. So bribery is the correct term for this. This is trying to change the mind of legislation. This legislation authorizes the Attorney General to pay the states to enact laws that are unconstitutional, perverting the judgment of the legislatures, perverting the judgment of law enforcement and judges within the states that accept these bribes. Further, it's an attempt to get the legislatures to ignore the will of their citizens in order to get this particular bribe. So every time you hear the government say grant, most likely the term they should be using is bribe. And think of this. Bribery is an impeachable offense. Under Article 2, Section 4 of the Constitution, any civil officer of the United States, quote, shall be impeached and upon conviction removed from office and disqualified from holding any office in the federal government under Article 1, Section 3, Clause 7. How can House members vote for such a bill? Because should any federal official actually act on it, actually issue money, authorize money, it is required by the Constitution that that very same House member impeach the official for following the law they created because they are bribing the states. Now, what are they bribing them to do? Well, they want them to pass certain state laws, and wow, this, like I said, this is pretty repugnant. I'm going to read from section 4. Facts supporting the law enforcement officer's probable cause to believe that the individual is dangerous and in possession of a firearm. Notice, there is no crime. There is no charge. There is no bad act. The person is accused of being dangerous and in possession of a firearm. So the facts supporting the law enforcement officer's probable cause, including a description of the law enforcement officer's interaction with the individual or with another individual who provided information relating to the individual against whom the warrant is sought, and who the law enforcement officer determines is credible and reliable. The state law requirements do include the need for a warrant, and it's supposed to be supported by affidavit. But look at the requirements listed for that affidavit. The first thing I want you to notice, yes, they say there must be probable cause that the person is dangerous and in possession of a firearm. Dangerous is not an action. Dangerous is a description. I won't torture my editor wife and family with trying to describe the parts of speech, but anything's dangerous. But notice, if the person is deemed to be dangerous, they don't deal with the person. It's not that they have or are about to commit a crime, which means if there's probable cause, the person is dangerous. And if the person is dangerous, why is the law enforcement officer not detaining the person? Because there is no legal justification for them to do so. But yet they're trying to create a legal justification to seize their stuff. And if no crime is committed and no danger that the person is an imminent threat shown, and that is an important legal point. For those of you who are familiar with self-defense laws, you have to show imminent threat. So if there's no crime and there's no proof of or reasonable or probable cause of imminent threat shown, why is a person's private property being seized? It's because it's a firearm. At least that's my understanding. The law admits it's the person who is dangerous, but then uses that to confiscate the private property that someone doesn't like, or more accurately, that someone doesn't trust everyday Americans to possess. Think of it this way. We've been focusing a lot on firearms. I want to go back. What if it wasn't a firearm? What if Congress passed a law bribing the states to confiscate the vehicles of, like I said, people who might get intoxicated and be in possession of a car? I'm not talking about impounding a vehicle of someone caught actually breaking the law. I'm not talking about being stopped at a DUI checkpoint. I'm not even talking about being a bartender calling the police and saying, I have a guy or a lady in my establishment who is intoxicated and I'm afraid they're going to go drive a car. No, we're just saying, hey, I think this person might be dangerous and might be in possession of a car. Let's go take the car. And again, we're not talking impounding. We're talking seizing, and as we'll see later, disposing of private property because someone claims they may do something dangerous. The Fourth Amendment says, as we said, the right of people to be secure in their purses, houses, papers, and effects. How secure is your property if now the federal government is going to bribe the state governments to seize on the word that someone says is credible? Where's the proof? Now, again, there are situations, and I understand where someone is shown to be a threat to others, but we're not talking about a threat to others. We're talking about dangerous. Where is this due process? Where's that Fifth Amendment guarantee? Nowhere in the required state legislation that they have to have in order to get the bribe is the right of the accused to be tried and found guilty before their property is taken. Instead, there must only be probable cause based on someone else's belief that the individual is dangerous. What if my idea of shooting squirrels off the back porch is considered dangerous by my neighbor? Even though I'm firing in a safe direction, I'm following all the universal gun safety rules, but my neighbor thinks it's dangerous. I'm not endangering anybody but the squirrels. But what if my neighbor has an irrational fear of firearms? And he thinks just because I have them in my house, I may decide one day to go over to his place and shoot him up. Would they believe I'm dangerous? Even though most rational people and most people who know me would say, no, Paul's not only dangerous, well, except maybe to squirrels. What about the accused? Because they truly are being accused. What about their right to face their accuser? You see, if someone other than a law enforcement officer makes the accusation, the accused has no opportunity to confront their accuser. They have no opportunity to really defend themselves against them, and what very well may be a false claim. If you don't know who's accusing you, how can you say, well, sure, that person doesn't like, he's my neighbor and he's been looking for a reason to get rid of me for 20 years. I don't know because I don't know who it is. No, the only standard for deciding if a third party's evidence is sufficient for probable cause is the judgment of a single law enforcement officer. When did we give up our right to due process? When did we decide that the judgment of a single individual is all that is needed to punish us as if we've been convicted of a crime? And when did putting on a uniform make the judgment of an otherwise fallible human being perfect? I love law enforcement officers, and 95% of them are great human beings doing very hard work, and they get very little respect for it. But there are some bad apples, and there are people who just don't know. If someone comes up, a law enforcement, they don't know me, they hear someone said I'm dangerous, they have no basis to determine whether I am or not. Now, once they come and steal your stuff, well, you do get a hearing. But listen to this. In general, not later than 21 days after a return is filed under paragraph 3, the court shall hold a hearing to determine whether the individual is dangerous. If the court determines that the individual is dangerous, the court shall, and we're going to go into some more legal language. My first question is, why in general? Why isn't there a definite time frame by which the court must hold a hearing? Your stuff has been taken. Your property has been violated by the government. Don't they owe you a chance? What if the prosecutor or the court delays the hearing more than 21 days? What happens? Do you automatically get your firearms back? I mean, this is not a criminal matter. So the accused is not covered under the Sixth Amendment right to a speedy trial, though it does actually fall under the definition of a suit. See, a suit is a petition, a seeking for something by petition or application. In law, an action or process for the recovery of a right or claim, legal application to a court for justice, prosecution of a right before any tribunal. The law enforcement officer is seeking to confiscate your property before a tribunal. And since it's pretty rare to find a firearm worth less than $20 nowadays, the Seventh Amendment requires that the right to a jury trial be preserved. So while the law determines that while the law determines what the court shall do if the accused is determined to be dangerous. So in other words, you've been accused of being dangerous, your stuff has been taken, and now you stand before a judge, a single person, who says whether or not you're dangerous. And if they decide that you're dangerous, the police keep your stuff. There is no requirement to return the seized property if you are not found to be dangerous. That language doesn't exist in this bill. There's no requirement that the law include language to return your seized property. So you've been accused, you've been found in effect not dangerous. Where's your stuff? How do you get your stuff back? How long do they have to hold on to your stuff? And guess what? There is no penalty requirement for either the law enforcement officer or the third party for making a false claim against the accused. So if you have, again, a neighbor, a disgruntled spouse, someone who just doesn't like you, they can keep coming back and back and back, and there's no penalty, at least not required by this federal law, this federal bill. A little later down, he says, all right, so if you're found to be dangerous, let's see, there'll be an order that the court shall order that the law enforcement agency maintain possession of the firearm. The court is ordering that the property of a person who has not been convicted, or in fact charged with a crime, be stolen by a law enforcement agency. Yes, stolen, steal, to take and carry away feloniously as the personal goods of another. To constitute stealing or theft, the taking must be felonious, that is, with an intent to take what belongs to another without his consent. See, while the stated intent is to prevent a potential crime, intentionally taking someone's property without their consent means they are stealing it. In the situation described in this law, the property involved is not evidence in a crime. It is not the ill-gotten gains of a crime. What's described here is state-sanctioned theft, nothing less. The government's supposed to protect your rights, but here we see them stealing it. And oh, by the way, subsection 2, in the case of an individual who has a license to carry a firearm, revoke such license. So in addition to having them steal your stuff, they're going to revoke your firearm license. Again, with no due process. There's no trial. There's no jury. There's little opportunity to provide evidence. There's no opportunity to face your accuser. There's no opportunity to call witnesses in your favor. None of that's required. This is, and again, an excessive fine because they're taking your property, which could be worth thousands and thousands and thousands of dollars when you haven't committed a crime, simply because someone accused you and the judge sided with them. Does nobody else find this as repugnant as I do? In effect, you're being fined by the confiscation of your property worth some amount of money because someone believes you're dangerous. Does that seem like an excessive fine to you? Let's see. We're running a little long here, so let me speed this up. The court shall provide notice of such a hearing to the government and to the individual from whom the firearm is seized. Great. How much time do you get? What about your right to legal representation? That's right. The government's stolen your stuff, and if you want it back, you got to go to a hearing, which means you're probably going to have to hire a lawyer. Who pays for the lawyer? And if you use a public defender, remember, they work for the government that just stole your stuff. We're the protections for the accused. If you're arrested and the officer does not recite you the Miranda rights perfectly, the charges against you are dropped. Here, your rights are being trampled on in a dozen different ways, and nobody cares. Now, the law does require that that the burden of proof is on the government that you're dangerous by clear and convincing evidence that the individual is dangerous and that the firearm should not be returned to the individual from whom it was seized. Great. The government's always supposed to have the burden of proof. But what is clear and convincing evidence? Does speeding make you dangerous? How about mouthing off on Facebook? Does that make you dangerous? You see, in the minds of some, simply owning a firearm makes you dangerous. What if the judge doesn't think civilians should possess a firearm? Does the state only need to convince him or her that you're dangerous? Could owning too many firearms or having too much ammunition be considered dangerous? Let's face it, if someone threatens you or your family and you're prepared to defend yourself, aren't you dangerous to them? What about a situation where The wife has I understand there's situations where there's someone is a real threat, right? Like I said, I pick on a nasty divorce, and 9 times out of 10, if the husband is dangerous, one of the two is going to be dangerous. Let's say that the wife is worried that the husband, he's a hunter, he has guns. She's worried. Okay. There has to be a higher level than just, I'm worried that he's dangerous before you take the stuff. Because what happens when the husband goes to the lawyer first, goes to the court first and says, hey, my wife may be dangerous, just so she can't protect herself from him. Because remember, she loses her license. How many times have we seen battered spouses killed waiting in New Jersey? One was killed waiting for her carry permit so she could defend herself. See, there's so much room for abuse. You could land a 747 with room to spare. And there's no right of appeal. A single judge makes this decision. Then, if you either are found not dangerous or found dangerous, you can beg for your stuff back. In Section 5, beginning on the date 180 days after the date the court entered, an individual against whom such an order was entered may petition the court for reversal of such order. The court shall grant a petition filed on the subparagraph if the petitioner proves by a preponderance of evidence that the individual is not dangerous. In other words, now that you've been found dangerous, you have to prove yourself innocent. After 6 months, how do you prove yourself innocent? What would the judge allow in their courtroom? Would the fact that you haven't done anything dangerous in the last 6 months be sufficient? Meanwhile, the government's still in possession of your stuff. Have you noticed there's no guarantee that the law enforcement agency take care of your property? Even if you get it back, who knows what condition it's been in? Maybe it's been stored in some damp, nasty basement. Who knows if it'll be a functional firearm? What recourse have you got? What recourse is required by this bribe for the permanent loss you may suffer? And if in 5 years, they may just decide to destroy it. That's right. 5 years after the order is entered, if the judge still thinks you're dangerous, they destroy your stuff and they dispose of it, which in most locales probably means destroy. Now, you can ask the government to sell your stuff. Okay. Let's see. In general, an individual whose firearm were retained by a law enforcement agency pursuant to an order under paragraph 4A1 may petition the court for a law enforcement agency to sell the firearm in accordance with applicable policy of the jurisdiction in which the firearm was seized and provide the proceeds of such sale to the individual. The court shall grant such order unless the serial number of the firearm is damaged. Law enforcement agency ordered to sell a firearm under this section shall sell the firearm not later than 1 year after the entry of such an order and may retain not more than 8% of the sale cost to cover the cost of the sale. So at least now, after the law enforcement agency has stolen your stuff, you may convince the court to make them sell the stuff and have them keep a cut for the cost of selling the stuff they stole from you in the first place. Hey, does that mean that when a thief breaks into your house and steals your wife's jewelry and he gets caught with it, that he can sell it and keep a cut of that as well? Because that's basically what's happening here. And under Section 5, quote, there is authorized to be appropriated $50 million to carry out this act for each of the fiscal years 2019 through 2021. Here's the payoff. Here's the bribe. Congress is supposed to appropriate $50 million a year to bribe states to pass these unconstitutional laws. It's $150 million of your tax money, my tax money, to bribe state legislatures. Now, some states already have these so-called red flag laws, and they're very similar to the ones that are described here. Whether you think the idea of pre-crime laws is good or not, do you really think it's the role of the federal government to bribe states to create them? Because if bribery doesn't work, how long before Congress simply uses intimidation? You see, if the federal government can't bribe the states to enact laws we like, what's to keep them from using our own money to bribe the states to pass laws we don't like? It's clearly a violation of the 10th Amendment. It's clearly a violation of separation of powers. In fact, to me, this is evidence of a lawless republic where Congress simply, they're going to ignore the law, they're going to ignore the Constitution and do whatever they figure they can get away with. This is proof that the federal government has actually becoming a criminal enterprise, no different than the protection rackets gangs use against local shop owners. Because they're going to use their ability to tax and borrow to get what they want by any means necessary. Since some in Congress will bribe, coerce, and steal to get their way, the real question is, will we let them? So what can you do? First, I would contact your state rep and your state senator. I've contacted mine. I'm setting up a meeting with them. Preferably contact them in person. Makes a big difference when you do that. Inform them of the illegal nature of these red flag laws. Ask them if they're being proposed. In fact, if you want, head to the website, constitutionstudy.com. You can find the articles. You can find all the quotes. You can find all the references as to where what's wrong with these that you can use when you talk to them. Be polite, but let them know in no uncertain terms if they support the violation of the Constitution, you will work to remove them from office. I'm about to have a very uncomfortable discussion with my state rep. I'm going to, if he supports, we have one here in Tennessee being proposed. If he supports this, I'm going to let him know that his constituents, that he's willing to take a bribe from the federal government if that law gets passed, that he's willing to authorize the stealing of private property without due process. I'm going to let them know that their state officials maybe accept their bribe to do this if they're getting federal money for it. And I'm going to ask, and any state official that imposes this, I'm asking for articles of impeachment. Don't make it an idle threat. We need to be prepared to work against anyone who'd vote for this nonsense. This is heinous. This is corrupt. This is criminal. Even if we like their other positions, how can you trust them? Even if you like other legislation, how do you trust that they will actually fulfill their oath? Because if they're doing what you like today, they can do what you don't like tomorrow. Next, I would schedule a meeting with your House rep. In fact, the next time they're in the local office, I try and schedule a meeting with them. Show them the corruption inherent in such legislation. Show them the bribery behind it. Back them to the hilt if they oppose it, but bury them if they don't. We need our elected representatives to be more afraid of us than of Michael Bloomberg or George Soros or any of the other billionaires who want to buy our American republic. We may not be able to spend $1 million on their campaign, but what if 10,000 of us gave $100 each? And what if that same 10,000 made sure to spread the word about their representatives supporting the bribing of the states? See, the only way we can do this is by working toward the same general goal, that of a constitutional republic where the rule of law matters. And the representatives of the people actually represent all the people, not just the ones with money. It's taken over 100 years for us to get into this mess. We're not going to get it back overnight, but it is time we started making the elected representatives more afraid of we the people than of the people donating to their re-election campaign. So that's my tirade on red flag laws. I've been seeing some activity here in the comments. Let me take a minute, go through here, see what we have. So why are we not filing lawsuits against the government? Well, really the problem we have with lawsuits against the government is, where do you file them? With the government. See, the problem is lawsuits, most of the sides are against you to begin with. The judge works for the government, the prosecutor works for the government, and unless you got a lot of money, the defending lawyer works for the government. So you're really kind of stacked. to me, the way the government, as I was designed, it's really up to us to hold our elected officials accountable, to talk to them and say, what you're doing here is wrong. And if you're going to violate your oath of office, we're going to work to get you out. And it's really up to us to say, to stop voting based on our pocketbook and start voting based on principles. We have state constitutions. Ooh, do states have the right to make a law that goes against or contradicts the Constitution? That's an interesting question. That's a good question. If you read Article 6 of the Constitution, in fact, let me find it so I can quote it, because I have a mind like a steel sieve, and I don't want to misrepresent it. Where'd it go? There we are. I have, by the way, if you ever want, you can find just about everything you're looking for online. And I closed down several of my pages, and I didn't have the tab open that had the Constitution. Article 6 has two very important clauses in it. Come on. Yes, I'm getting the warning that says the government's closed. And I'm saying, even though I've told it, leave me alone. Constitution, transcript, Article 6. Article 6. Let's see. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. So the answer is the states can pass those laws. There's nothing that stops a state from passing a law, but both the state judges and the federal judges are supposed to put the Constitution above the state law. So if a state law is repugnant to the Constitution, judges should find it, should judge against it. Now, there's a whole big thing about judges finding something unconstitutional and how the court system is, and that's actually a fairly long and involved discussion. The short answer is, if they pass such laws, the judges, in fact, if you continue in Article 6, the senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. So guess what? All of your state legislatures, all your state officials, all your state judges are required to swear or to affirm to support the Constitution. So they're violating their oath. And again, we need to educate them as well. But really, it's a question of should the state judges, when they review a case involving that law, should say, but this law is unconstitutional. It's also a scenario where if it's a jury trial, you have the question of jury nullification, which again is maybe a topic for another day. It's very interesting. There is there is only one U.S. Constitution. It's been amended 27 times. We had the Articles of Confederation before then, but there's actually one document referred to as U.S. Constitutions. Most of the states, their first draft of the Constitution was before the U.S. Constitution was adopted. In fact, Massachusetts, I believe, has the oldest Constitution still in effect. It was adopted 6 years before the U.S. Constitution. Under the incorporated Constitution, they can do whatever they want. That is not true. As I just read from Article 6, there is what's called the selective incorporation doctrine, where back in 1833, the Supreme Court said, no, the Bill of Rights doesn't really apply to the states, even though Article 6 basically just said the judges have to follow it. So that's an interesting scenario. Let's see. some interesting conversations going on here. Looking for more questions. A lot of comments and conversations going around here. Not seeing as many questions. Let's see. They do not follow. Well, I'm not sure who they. I haven't been following the thread, so I'm not sure who they are. But yeah, there's a lot of people who don't follow the Constitution. In fact, I've talked to several lawyers, and as I understand it, lawyers are not trained in the Constitution in law school. They're trained in constitutional law. In other words, they don't actually read the document. They read a commentary about the document. In fact, they read a commentary about the commentary about the commentary about the commentary about the document. It's kind of like a giant game of telephone, where you whisper something in one person's ear and it kind of goes around the room and gets changed along the way. And that's kind of where we sit right now. So that's kind of why we're here, is so that we can educate ourselves directly from the Constitution. It's a mess, but we have to work on it. Again, I'm looking. There's an interesting comment. Looking to see if there are any questions here. Yeah, other examples of things being. In pursuance thereof. Dustin made an interesting point. When I read Article 6, I kind of rushed through it. There is a hierarchy. There is the Constitution, and it says laws made by the United States in pursuance thereof. That means, and pursuance means following the Constitution, not just the process of the Constitution, but actually following the Constitution itself. So when the Constitution says, you cannot take someone's property, a federal law that violates that is actually considered by our founding fathers null and void. It's of no value because it's not the supreme law, because it wasn't following the Constitution. And to see both. Interesting quotes. Is there any power in the constitutional law? Actually, it's in the Constitution itself. So one of the misconceptions about federal judges is this concept of lifetime appointments. If you read Article 3, it's Article 3, Clause 1. Let me come back here. By the way, you may notice I like quoting directly from the document so I don't stumble over anything. Article 3, Section 1, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall, at stated times, receive for their services a compensation. Federal judges only serve during their good behavior. Well, the interesting question is, who defines good behavior? If you do a little research, it's actually the House. The sole power of impeachment comes from the House. So basically, it's the people who represent us. Right? The two houses, the House of Representatives represents the people. The Senate's supposed to represent the states. The members of the House look at what a judge does, and they can decide if it's bad behavior. I'm doing a little research. As I understand it, there were 97 impeachment proceedings early in our nation. And I'm trying to find the research because I've heard some very interesting things. I mean, I've heard about, as I understand it, no judge was impeached for an opinion they wrote. And I can understand that. But they were impeached for other actions that caused issues. And I want to find some more details before I go into further. So, but that'd be another interesting one to follow up on that. How many clauses are in the Bill of Rights for due process? There are two amendments or in the Bill of Rights, I think, that specifically mention due process. But the idea of what due process is actually Amendments 4 through 8. So Amendment 4, which is the search and seizure warrants. Amendment 5, which is grand juries and self-witness. Amendment 6, which is speedy trial. Amendment 7, which is excessive fines. Amendment 8, I forget what that is off the top of my head. But basically, Amendments 4 through 8 are called the due process amendments. They're the amendments that deal with what is due process. So if you want to do some research on that, that'd be great. Shameless plug, I actually wrote an essay. It's available up on Amazon in both paper and ebook dealing with the Bill of Rights. So you can go get some information there. Administrative law is not constitutional. Admiralty law is not constitutional. Actually, in the Constitution, in Article 1, Section 8, Congress gets to determine how we deal with maritime, what we now call maritime law. So that's another one, a little long to get into. It's going to take the power of the people to fix this mess. Yes, I absolutely agree. My concern is when I look into the future, I see either one of three things happening. I see either we just roll over and continue down this road to tyranny. I see a bloody fight, or I see a battle at the ballot box. Of the three, I would prefer a battle at the ballot box. It requires us to educate ourselves so that we can hold our elected representative officials accountable. We know what our role is in running the government. We know how we can better choose elected officials. And that actually, I think, would fix a lot of what's going on. There's a lot we can talk about along that line in the future. But I'd much rather see us fix it at the ballot box than on the battlefield. It's interesting, the Second Amendment is being infringed, but what you really see here, and I may be wrong, but from everything I've seen, what they're really doing is they're going after the people that own the guns. This was shown to me a couple of years ago. But if there's a shooting, if there's a problem, who are the first people that get called? In other words, if you're being held up or if there's something going on, they call the people with guns. The problem rarely is the gun. The problem is they don't want civilians to have the gun. And while there's a lot of discussion about the Second Amendment, remember its purpose. They say a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. We have a Second Amendment so that we can keep our states secure. That is its purpose. It's not for hunting. It's not even for individual self-defense as much as it is so that the states can defend themselves. Well, and see, and that's Timothy, make a good point that the ballot box the ballot box isn't the sole solution of the problem. The point of the ballot box is if we, there's a joke out there. How can you tell when a politician is lying? Well, their lips are moving. And as much as that is a dig on politicians, to me, it's a dig on the American people. We hire these men and women to represent us. They are our representatives. Whether we voted for them individually or not, they've been hired by us to represent us. And if you think that is the example you want to show the world, that's the problem. See, if at the ballot box, we chose better representatives, in other words, ones that weren't two-faced, ones that actually upheld their oath of office. The problem is so much of the system is rigged against an individual like that. They can't get in unless the people truly stand behind them. That's why I say it's going to take, I would see a solution at the ballot box, because if we had representatives and senators who read and understood the Constitution, read and understood their role in the government, and were held accountable for their actions, meaning if you violate your oath of office, you're gone. You don't come telling me what great programs you did. You violated your oath of office, you're gone. There's another story in there, but we're getting late in the hour, and I think we're about time. Let's see. Universal background checks. Yeah, again, that's a whole rabbit. It's not. I just don't have time to get into it. We already have background checks. There's an infringement question in there. There are so many things involved in there. The system is busted, and I don't want to give it half measure. I really, if I want to talk about it, really would like to spend a proper amount of time on that, than going in. And yeah, actually, Alicia brought up a point which I want to take a moment on. We've handed over our kids to be educated by the government. I was educated by the government, and it was only the fact that I went and learned for myself that I understood certain things. We have to take responsibility for educating our kids. One of the quotes I use a lot in the Constitution study comes from John Jay. It is incumbent on the people to read the Constitution of their nation and to teach the rising generation to be free. And it goes on about recognizing and defending your rights, but that's really the important point. It is up to us to read and study the Constitution for ourselves. Why would you be surprised that the government doesn't tell you you have authority over the government? The government is just people, remember. The government isn't some magical entity. It's people. So yeah, it's up to us to teach ourselves, because our government has no real incentive to do so. And it's kind of a mess. Before I head out, we've been about an hour. I want to be cognizant of your time. I don't want to drone on too long. Let me know if this is too short. Let me know if this is too long. I'll be looking at the comments as well afterwards. I want to thank, as I did, Dustin and Jesse at the Constitutional Grassroots Movement. Don't know why that sticks in my head. Dustin they also deal with Restore the Intent, where they're trying to set up studies in every county in the nation. Head over to my website, if you wouldn't mind, constitutionstudy.com. You can find out more about what we're doing there. You can find out other studies and other material that we've got. I've loved some of the questions. It's been very interesting. I hope you found this enjoyable. I hope you found this interesting. Please let me know. I'm doing this as kind of an experiment, and I do kind of want to find out whether you liked it, whether you'd like to see more of this, or whether I'm, trying to push a rope. So with that, I'm going to say, let's have a great day. Read, study. Let's teach the rising generation to be free. This is our nation. This is our Constitution. Let's make sure we stay in charge of it. Thank you. Have a great night. God bless the people of the United States of America. And I want to see you next time on the Constitution Study Live. Thank you.